And the record shall show that all parties are present and the jury is present. And Mr. Towson, I understand you are the jury foreperson.
Yes, sir.
We have received a message on behalf of the jury that the jury has reached a verdict in this case. Is that true, sir?
Yes, sir, we have.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury.
Yes, sir, it is.
Do any of the jurors disagree with your foreman's representations? No disagreement is indicated. It does indeed appear to be unanimous. I'm going to ask you to pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict here. And the defendant shall rise. In cause number 24, CR 2417. The state of Texas versus John W. Dixon, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes, and you may be seated. At this time, ladies and gentlemen, I have received your verdict finding the defendant guilty of the offense of aggravated assault as alleged by this indictment. That brings us to a close of phase one of this trial. We are going to now proceed with phase two, the punishment phase of the trial. Please be mindful that you are still under the instructions that the court has given to you up to this point. And let me see the lawyers for just some of this. All right, we now recall cause number 24, CR 2417, the state of Texas versus John W. Dixon. The defendant has been found guilty of the second-degree felony of aggravated assault with a deadly weapon by the jury. I'm going to ask the bailiff to bring forth the defendant, and thereafter, we will bring forth the jury. And then additional evidence can be provided by both sides. And of course, thereafter, we'll then read the jury charge and arguments of counsel will be made in that order. All right. Anything to bring up by either party before we bring the jury in?
No, Your Honor.
No, Judge.
All right. I asked the bailiff to bring the jury forth. Thank you. All right. The record shall show the parties, all parties are present and the jury is present. Ladies and gentlemen of the jury, again, at this time, for the record, I have received and accepted your verdict finding the defendant guilty of the offense, the second-degree felony of aggravated assault with a deadly weapon as charged in the indictment in this case. That closes phase one of this two-part trial. We will now proceed to the punishment phase of the trial. And once again, let me repeat, you are still under the same instructions that the court has given to you up to now. And at this time, any opening statements?
No, Your Honor.
No, Your Honor.
All right. The state of Texas may open and close the presentation of evidence like they do in the guilt or innocence phase. What says the state of Texas?
Judge, we'd ask that all the evidence from guilt or innocence be admitted into the punishment phase and then we'll rest.
All right. And that is the law. You are allowed to consider all the evidence presented in the punishment phase from what was not only presented in the punishment phase, but what was presented in the guilt or innocence phase. The state has passed on the presentation and they're standing by the evidence presented. The defense may call your witness.
Yes, Judge, we call John Wayne Dixon Sr. for the stand.
Your witness.
Thank you, Judge. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
I'm John Wayne Dixon Sr.
And how do you know my client, John Dixon Jr.?
That's my oldest son.
Okay, that seems simple enough. Same name and everything.
Right. Cheers.
How many children do you have?
Two, a boy and a girl. Two died.
You said John was the oldest.
John, you got a girl older than him now.
So your daughter, who is still with us, is older than John.
Right.
Okay, got it. Can you please just tell me a little bit about John and his background, just to continue to introduce him to the jury, please?
John is my son, like we all know. I never had a problem with John, to be honest with you. John was a good kid all through his life. He graduated from high school, played football. Never gave me any trouble, and that's understood too. Now, he might have had arguments with his sister, you know.
Sure,
like,
just sibling issues.
John never been in trouble. And like, I don't even know if he got a driver's license ticket.
But in terms of criminal history, he doesn't have any felony convictions. And outside of that, you just don't really know if it's traffic or whatever. But you know for certain that he doesn't have a felony conviction on his record.
He don't have a misdemeanor as far as I know.
Okay. Having John as a child, tell me how he was growing up.
He's a great kid. It's been imagine that's my son named after me. Of course, it was a promising experience for me to have him born, and I welcome him in my life any time of the day. He is a good, the young man is a good man.
And then as he got older, what are some ways that you saw him grow into that good young man like you're talking about?
Well, in the beginning of it, me and his mother was together. Then we separated, and John always been in my life. That's my, son, and sister the same way. But speaking of John, he always been considered to other people. He always was taught right from wrong. But he also did a lot for the public, with older folks. He always did like older folks, same as me.
Okay, and whenever you talk about him liking older folks, what do you mean about that?
He would do different things for people. He got a good heart.
Okay.
I always told him that to follow his heart, as much as he can and do the things. I took him to Austin with me for the initiative that I was working in. He really good. Like I say, he never gave me any trouble. Graduated, that was the main thing. I wanted him to graduate.
Right.
And I never had to go to school for him. And me and his mom was in criminal justice together. She was J-Lo, what else she did at our job, and I worked here.
Okay. And in terms of, you were talking about his impact with older folks, do you feel like he contributes to his community?
Yes, yes, I do.
Do you feel like he should be trusted in his community?
Yes, most definitely. I think he should be given a chance to explore some of the areas that he needs to explore. And I would definitely help out with that.
Okay, thank you. Pass the witness, Judge.
Mr. Dixon,
Yes.
I won't take up too much of your time. If you were sitting on the other side and that was your son that got shot, just inches away from his heart, how would you be feeling about the person that shot your son?
Well, I guess I would have a feeling about it, but at this particular time, all this time I have clean and sober, I don't look at people like that.
All this time clean and sober, what do you mean?
As me, I work for the Jefferson County alcohol drug review.
Okay, but you said as you look at it clean and sober now, were you not clean and sober before?
Oh, I've had with drinking before.
Okay.
I had no problem.
But if that was your son, who had to have half of his intestines removed, small intestines removed, had to have repair on his kidneys and other parts of his body because 2 bullets went through him, would you be upset?
Well, I probably would to a certain extent, but the way it happened, I don't know. So I couldn't tell you. All you showing me is some pictures of what happened.
Okay, but you wouldn't be upset if your son you'd be somewhat upset.
Well, of course I would. I wouldn't want to see him in that position.
Would you be upset with the person who did it to him?
Of course I would.
Okay.
I'd be upset the way they handled it. I don't think it should be handled that way, but that's the way it is.
And would you think somebody that shot your son should be running around out in public, still able to do whatever he wants to do while your son's got missing parts from his body?
Well, in that case, it's a little different because, he was the one that the guy you showed me, he got shot. I didn't want him to get shot now to get into that. But, I got sympathy for him. But I mean, what can I do? I mean, you found him guilty. I just know that he's entitled to, he could probation or something. So I would love for him now.
So you won't say that you'd be so mad at this person who shot your son that you'd want him to go to prison?
No.
Okay, I'll pass one.
Is he? All right, you are excused, sir. Next, please.
Defense rests.
Okay, anything else?
Nothing,
Madam Parties? All right, the court has prepared a jury charge for this punishment phase. If the parties had an opportunity to review it, are there any corrections or changes to it? State.
Nothing from the state, Judge.
Nothing.
Defense. All right. As before, the state of Texas may open and close final arguments. What says the state of Texas?
State once again waive its right to open, reserve its right to close, Your Honor.
You may. And the defense may go forward when ready.
Thank you, Judge.
Yes, ma'am.
May it please the court, counsel, jury members. We thank you for your verdict. We appreciate it, though it wasn't the one that we had hoped for. We respect it and we respect this process, and I appreciate your time and attention to these matters that we've been dealing with. Now that we are kind of nearing the end of the trial, you have another decision to make. You've already found him guilty, but now since it's a two-part system, like Judge has been telling you, you have to assess punishment. And throughout punishment, you have the option to give him probation. You're also considering that big range for a second-degree felony of anywhere from 2 all the way up to 20 years in prison. And if you're sitting there wondering if my client, Mr. Dixon, is a good candidate for probation, I would argue to you that you already know that he will be. Throughout this whole process, he has been nothing but cooperative to Beaumont Police Department on the scene. He didn't cause them any issues. He called 911. He was and showed that he did everything that you would want someone in that position to do. You would hope that they would cooperate, that they would show up and act in the way that he did after this happened. And I submit to you that he would be willing and able to follow those same conditions of probation should you elect to give him the option of probation. Thing that I would hope for is that we could give this young man a chance to reassimilate into society, given that he does have a large lack of criminal history. This is the only thing that he's had up to this point. If he's on probation, he's going to have to check in with somebody at minimum monthly, make sure that he's doing everything that he's supposed to be doing, and allow him to use that as a stepping stone to reassimilate into society and to be a productive member of our society. Give him that chance of rehabilitation. Give him that chance to show you that he can do it. And if he can't, if he doesn't, then he can always go to prison if it's revoked. That probation can always be taken away from him. But give him that chance to show you that he can do it. And if you feel that he is not a good candidate for probation, we again will respect whatever decision you make because it is in your hands. If you feel like he should get some jail time in some capacity, we would ask for the minimum of that. So I thank you for your consideration. I look forward to hearing what you have to say. And I look forward to hearing what you decide John Dixon's fate is going to be. Thank you.
State of Texas.
First of all, before I begin, thank you for your time. Y'all don't understand how important it is when we have what we got going on in our community for people to come up here, take time out of your lives and do this. I told you at the very beginning in Vordaer, I told you I'm going to ask you to put him in prison. Y'all know that's coming. I told you I've never changed my mind. I hadn't changed my story. I hadn't changed anything since the beginning. And the reason I'm going to ask you, I'm going to tell you why in just a moment. But first, I'm going to tell you something. As a prosecutor, I've been a defense attorney and prosecutor, and every time we come down to one of these punishment phases, and I ask people to place someone in prison, I know how serious it is. Okay. I know that what I'm asking you to do is something very serious, but sometimes in our society, there are just things that you just have to do as a citizen, just like police officers running out to where there's people shooting, just like where there's soldiers out there defending our freedoms. There's things that you have to do as a citizen, like sitting through a trial and coming up here and being uncomfortable and doing things. But it's something that's necessary, and it's necessary because we have to keep our community safe. What's that got to do with this young man? I keep going back to the same thing over and over, that this man right here could have died. As much as we laughed at some of the things in the defendant's statement because of the way he acted, sometimes it made you smile, sometimes it made you do some things. But when you get down to the serious nature of this, he lost parts of his body and he could be dead right now. If he hadn't got medical assistance, he would have been dead. Okay, if he'd been laying there for too long, he would have been dead. That's just how serious this is. The other thing you need to remember is that every time you get up in the morning, we talked about this in Vordaer, you're reading in the newspaper where a fist fight turned into a gunfight. And you say, well, how can you blame that on him and part of his problem? Well, now he is part of the problem because he was involved in a fist fight and he shot somebody. So he's part of the problem. Now, the other reason is this. It's a logical reason, and it's not an emotional reason about trying to say this guy's dead. But logically, if he was dead right now, we'd be talking a lot of time, 5 to life and no probation. And it's just a matter of the fact that either somebody moved or he's not as good a shot as he thought he was, or he just twitched a little bit when he shot 2 times, but this man's not dead. So that's how serious this is, because we could be here looking at an autopsy picture of this man, Curtis Satterwhite. Whether you like him or not, whether you agree with him or not, whether you think he should have gone out there and yelled at those people, even though all he was doing was minding his own business in the apartment, he wasn't causing the problem. The other reason is, and I'm going to tell you, it's just the same way with self-defense. And here's how this works. Because we talked about the fact that when you got your instructions, and when we talked in Vordaer about the fact that an aggravated assault is an assault and then you use or exhibit a deadly weapon. And so the ways you can commit an assault under 2201 of the Penal Code, a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse, intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse, or intentionally knowingly causes physical contact with another person who knows or should reasonably believe the other will regard the contact as offensive. So you've got the offensive one is a Class C misdemeanor. The threatening is a Class A misdemeanor. And then you've got actually causing bodily injury. So you see how it progresses. You're just offensive touching, you're threatening to hurt somebody, and then you hurt somebody. And then when you get to an aggravated assault, you can commit an aggravated assault by holding a gun while you threaten somebody, or you use it to cause bodily injury to somebody, hitting them or doing something else while you exhibit it, or you actually cause serious bodily injury by shooting them or by discharging that firearm or stabbing them with a knife. So you see how it progresses from a misdemeanor, Class C misdemeanor, whether it's a fine, goes up to a misdemeanor, and then it goes up to an assault, of aggravated assault where you're threatening somebody, and then it goes up to an aggravated assault where you actually cause bodily injury. So I want you to think about this. Probation would be for those people that maybe cause a little bit by slapping somebody. Probation for those people that actually just threaten somebody, because it progresses and it's more of a probation because you got a misdemeanor probation or misdemeanor punishment, then you got felony probation. So it goes up. It does when you're trying to assault somebody, you're defending yourself. What you do to respond to it is the same way you do in punishment. You look at it just like if your children are going to be punished. If they do a little thing, you give a little punishment. If they do something big, then you got to spank them. If you're a spanking parent, my children knew that when they got to a certain point, even if they did something little, it was just a, all right, you don't get dessert or something. But when they did something and it was big and they hurt somebody else, they were going to get spanking. And it wasn't pleasant for me. I didn't want to do that. But in order to correct behavior in our county, in order to correct behavior in this man, in order to correct the behavior in other people who are going to be in the same place, and you better believe they're going to be listening. What do you think the first thing they're going to ask him when he gets back to jail? What'd you get? And it's going to have an effect. You may not think it does, but it's going to have an effect. When they get back, when he goes to jail, they're going to go, what did you get? And if he says, man, I'm out of here on probation for shooting somebody, what do you think that's going to send a message to? How do you think it affects him? That he thinks the next time he can just make up a story again and just get probation. Guys, this is serious. And it's so serious that this man spent 3 weeks in the hospital serious, okay? This is not, I'm sorry, I feel bad. I feel uncomfortable about placing somebody in prison. It's that man right there was uncomfortable for 3 weeks while they were poking and prodding and cutting on him and trying to fix him to make him better where he could come out. That's how serious this is. And I hope and I pray that you don't go back there and start feeling sorry for the one who caused it. You can feel sorry for the fact that he has to go to prison and he ruined the rest of his life because you heard him say, man, I did that. My life will never be the same again. And yes, it's not going to be the same, but that was his decision, not yours. All this stuff is his decision, not yours. Your decision is, how do we react to what he did? How do we react to how he reacted? Did he react, I feel sorry for this man? Did he react, I feel bad that I'm probably going to put bullets in this man? How did he react to somebody doing something? He reacted by shooting him, which is a deadly weapon, deadly force, trying to kill him. And don't tell me he wasn't trying to kill him. He wasn't shooting at his leg or his arm or anything else. He was trying to kill him, guys. And then he went to the apartment. And you heard it on 911 tape. He was leaning over her and he was fixing to finish it off. And if you walk him out the door and he holds the door open for you walking out there, then you just tell the rest of the county, hey, you know what? It's okay. We feel bad for y'all. This is our community. This is your community. This is the county that you are making a decision for. You get to decide. It's not pleasant. It's not comfortable. It's not easy. And you're going to go home and you're going to feel, well, if you put him in prison. But how uncomfortable you gonna feel if you put him out on the streets again and he makes a bad decision again with a gun? And don't think that a probation thing is gonna keep him. Probation are the things that we're supposed to do. And one of the first things you don't do on probation is don't commit a crime. And why is he here? Go back, feel bad that he ended a little bit of his life, but he's not dead. He's gonna get out. He's gonna get on parole. You've heard this stuff. You don't get to consider how much of parole, but eventually he's gonna get out. And then that's up to him, what he does with his life from there. That's his decision again. He gets to decide. He gets to decide what to do with all this. Don't go back there and do something because it makes you feel uncomfortable. I don't want to do that. Go back there and seriously consider what this was, what it caused, what the ripple effect is, and what you need to do about it. I'm asking you to place him in prison. And I'm not asking you to place him in prison for 2 years because that doesn't do anything for anybody. It has to be a slap. It has to be something over 10 years. I don't care if it's I see a look. Already got a look. It's uncomfortable. I told you from the beginning, I asked you, can you do it? Can you consider 20 years? You said yes. I asked you. And I'm telling you that if that man died, would you be feeling sorry for him? Go back. Be a citizen and do what you have to do to make this county what it needs to be. Let them know we're not shooting a gun fist fights. We're not hurting each other. We're not killing each other. We're taking this serious and we're taking our town back, our county back, our citizens back. I look forward to your verdict.
All right, ladies and gentlemen of the jury, this time I'm tendering the jury charge for the bailiff. I'm going to ask you as before, please step down. Follow the bailiff into the deliberation room. We will await your verdict. And alternates, again, thank you so much for bearing with us and hanging in there with us. Thank you. And you can, thanks, Dan. We now recall cause number 24 CR 2417. The state of Texas versus John W. Dixon. The defendant is present with his attorneys and the state's attorneys. The court has received a message from the jury that the jury has reached a verdict in this punishment phase of this trial after finding the defendant guilty of the second-degree felony of aggravated assault. I'm going to ask the bailiffs to bring in the alternates and we'll bring in the jury and accept the verdict. The record shall now reflect that all parties are present and the jury is seated and standing in the courtroom. And Mr. Townsend, as foreperson of this jury, the court has received a message on your behalf that the jury has reached a verdict in this punishment portion of this trial. Is that true, sir?
Yes, sir, it is.
Is this decision a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, sir, it is.
Do any of the jurors disagree with your foreman's representations? No disagreement is indicated. It does indeed appear to be unanimous. As before, I'm going to ask you to pass the documents over to the bailiff. You may be seated. The court will review for proper form and publish the vote. That's good. The defendant shall rise. In cause number 24 CR 2417, the state of Texas versus John W. Dixon. We, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 10 years. Signed by the jury foreperson. It is received. It is made a part of the record for all purposes. You may be seated. Ladies and gentlemen of the jury, at this time, your duty as jurors is complete. At the beginning, I placed each of you under a number of instructions, and at this time, I am releasing you from those instructions previously given to you. You are released from your oath of secrecy. You are free to discuss this case in your deliberations with anyone. You are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by this court. In a few minutes, there are some formalities the court must attend to complete the record, but the attorneys in this case are going to be released and they always like to get input or feedback from jurors if you're willing to talk to them, and it'll be just a few minutes here, but you also are free to go. And others may want to question you about your experience here as jurors, your deliberations. And remember, you are free to discuss this if you wish and free not to. And you have every right to maintain your silence unless otherwise ordered by this court. The Constitution, the flag, begins with "we the people," and it is all about humans, fellow citizens of the United States coming forth and leading and working together and being part of a United States of America. And nothing more important and more reflective of that than in jury service, when citizens are called upon to make decisions about fellow citizens' activities or behavior based upon the law. And it's important that citizens come forth, and by your decisions, you echo the essence of the standards that our country was based upon: life, liberty, and the pursuit of happiness. And this court has done this long enough to know and appreciate that the process works. It's just making sure that people care enough about the process to come forward and serve as jurors. I want to thank you for your time and your service. I hope to have the honor to work with you in the future. Until then, may God continue to bless Jefferson County and her citizens, and you are excused. And alternates, thank you for your service as well. Mr. Dixon, you may stand, please. John W. Dixon, you came before this court and a jury, entered a plea of not guilty to the offense of a second-degree felony, aggravated assault with a deadly weapon, as set out in the indictment. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of this second-degree felony of aggravated assault. Thereafter, evidence was presented for punishment. The jury deliberated and assessed your punishment at 10 years confinement in prison. Is there any legal reason why sentence should not be now pronounced as to the defendant? Finding nothing to bar pronouncement of sentence, it is therefore the judgment of this court that you are guilty in this cause number 24 CR 2417, the state of Texas versus John W. Dixon. And the charge and conviction is aggravated assault with a deadly weapon, a second-degree felony. And you shall be punished in accordance with the jury's verdict. Having been adjudged guilty of this offense, your punishment is hereby assessed at confinement in the Texas Department of Criminal Justice's Institutional Division for imprisonment for a period of 10 years. And you will be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 10 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. The judgment shall reflect that a deadly weapon was used in the and exhibited in the commission of this offense, and that deadly weapon was namely a firearm. You are now here remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. Your sentence commences this day, and you will receive credit for all time of detention you have served as provided by law. Anything else to add, state and defense? We are in recess on this case.